Thank you, and good afternoon, Your Honors. In the interest of time, let me go directly to the constitutional issues involved in Resolution Number 7, entitled A Resolution of Both Houses of Congress proposing amendments to certain economic provisions of the 1987 Constitution of the Republic of the Philippines, particularly on Articles 12, 14, and 16. The resolutory part of the joint resolution reads as follows. Resolved by the Congress, upon the vote of 3/4 of all its members, pursuant to Article 17 of the Constitution, to propose amendments to Articles 12, 14, and 16 of the 1987 Constitution, etc. What does Article 17 of the Constitution provide? It provides as follows. Section 1. Any amendment to or revision of this Constitution may be proposed by 1. The Congress upon a vote of 3/4 of all its members, or 2. A constitutional convention. The meaning and proper interpretation of Article 17, Section 1(1), which read the Congress upon a vote of 3/4 of all its members, has been the continuing subject of debates between and among law and non-law experts, and between the members of the two houses of Congress. And to date, this issue has been unresolved. Until this constitutional issue is settled, all these talks about amending certain alleged restricted economic provisions in the Constitution may just be precipitate. How did this constitutional confusion happen? It is a case of unfortunate inadvertence, a case of unfortunate inadvertence on the part of the framers of the 1987 Constitution. According to the views of former Chief Justice Hilario Davide Jr., former Associate Justice Adolf Ascuna, and Christian Monsod. Initially, they said the committee in charge of amendments thought that a unicameral Congress would be adopted. Contrary to their expectations, however, the framers adopted in the last minute a bicameral Congress. And in the rush of things, they forgot to adjust their recommendation on how to amend the Constitution in the case where Congress is bicameral and meeting as a constituent assembly. Hence, we have this so-called anomaly. Article 17, Section 1(1) saying any amendment to or revision of this Constitution may be proposed by the Congress upon a vote of 3/4 of all its members, which is fit and proper for a unicameral Congress, but not for a bicameral Congress. This unfortunate inadvertence gave birth to two opposite school of thought on how Congress, when convened as a constituent assembly, should meet and vote. That is, whether they should meet and vote jointly or separately. The first school of thought maintains that provision in the Constitution is an admitted case of inadvertence. Hence, it should be interpreted in light of the fact that we have a bicameral Congress, and we should not stray from the tradition and the practice that when their members convene as a constituent assembly, they must meet jointly and vote separately. On the other hand, there is a second school of thought. The second school of thought is espoused by Father Joaquin Bernas, himself one of the framers of the 1987 Constitution. Father Bernas posits the theory that Article 17, Section 1(1) of the Constitution merely grants Congress the power to act as a constituent assembly to amend or revise the Constitution. Let me repeat the theory of Father Bernas. His theory is that Article 17, Section 1(1) of the Constitution merely grants Congress the power to act as a constituent assembly to amend or revise the Constitution. He then submits that how the two houses shall meet, how they shall vote, whether jointly or separately, is up for the senators and the congressmen to determine by the rules that they will adopt. That is the view of Father Bernas. And so, this is our constitutional quandary, Your Honors. How to interpret this Article 17, Section 1.1 in a manner that is aligned with the intent of its framers and in accord with the will of the people when they ratified the 1987 Constitution. My impression, Your Honors, is that by and large, both houses, the Senate and the House, are adopting the Bernas interpretation of Article 17, Section 1.1. Although there remains the divisive issue of whether the two houses will vote jointly or separately. With due respect, Your Honors, you can expect a constitutional challenge with the adoption of the Bernas model and interpretation. I'm not passing judgment on the merits or the demerits of the Bernas model. I'm discussing this only in the interest of a more informative, more enlightened discussion. And let me cite just two reasons why the Bernas interpretation will be subjected to a constitutional challenge. One, the view of Father Bernas is a personal view. That view of Father Bernas was never ventilated, never discussed when the framers of the 1987 Constitution deliberated on Article 17, Section 1.1. Father Bernas floated that personal view long after the 1987 Constitution has been ratified by the people. He floated that personal view only when he wrote his commentaries on the 1987 Constitution. In construing or in interpreting the Constitution, personal views do not carry much weight, precisely because they are personal views and do not reflect the consensus arrived at by the framers of the Constitution. Secondly, Your Honors, the facts established, the uncontroverted facts, show that this Article 17, Section 1.1 is there by inadvertence, by inattention, when the framers adopted a bicameral Congress instead of a unicameral Congress. In other words, Your Honors, there is nothing in the proceedings of the Constitutional Commission that will contravene the intent to adopt the traditional way of meeting, the traditional way of voting when Congress is convened as a constituent assembly. And that is meeting jointly and voting separately. The traditional way, the classic way, is expressed in Article 6, Section 1 of the 1935 Constitution, which states, the Congress in joint session assembled by a vote of 3/4 of all the members of the Senate and of the House of Representatives voting separately may propose amendments to this Constitution. That is the classic formulation, the traditional formulation, when a bicameral Congress meets as a constituent assembly in order to amend or revise the Constitution. Again, Your Honors, in interpreting the Constitution, one of the hallowed principles is always to know the intent of the framers. And knowing that intent, to enforce and implement that intent. This hallowed principle of constitutional construction may be violated if we disregard the reality that Article 17, Section 1 of the Constitution is there by inadvertence, is there by accident, is there as a clear error, for it is intended for a unicameral and not for a bicameral Congress. The question, Your Honor, is there a way out to settle this issue? This issue that cannot be settled by the legal experts. This issue that cannot be settled by both the houses of Congress. Under our Constitution, Your Honors, and this is my humble submission, there are two ways to settle this problem. The first way is the political way. The political way is to submit this issue to the people for their judgment, either in an obligatory or a non-obligatory referendum. Let the people speak on their intent when they approve this Article 17, Section 1 of the Constitution. Is there intent for the two houses to meet jointly and vote separately? Or did they discard the traditional understanding when they approved this Article 17, Section 1 of the Constitution. It can be argued that if the people speak on this issue, whatever is their judgment cannot be reviewed by the Supreme Court because it constitutes a political question which is beyond the jurisdiction, beyond the competence of the Supreme Court. The second way, Your Honors, is the judicial way. This issue can be brought for interpretation by the Supreme Court. Needless to state, the requirements of review by the Supreme Court should all be complied with. The requirement of ripeness of the issue, the requirement of standing of the parties, the showing of grave abuse of power. If all these requirements can be complied with, I am confident that the Supreme Court will settle the issue in the exercise of its power to interpret the Constitution. Let us remember that the 87 Constitution expanded the judicial powers of the Supreme Court. Article 8, Section 1 of the 87 Constitution expanded and redefined the perimeters and parameters of judicial power. It now reads as follows. Judicial power includes the duty of the courts of justice to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Your Honors, that phrase, grave abuse of discretion, is broad enough to allow the Supreme Court to settle this dispute. In other words, to make a proper interpretation of Article 17, Section 1(1) of the Constitution in an appropriate case. Your Honors, I wish I have more time to discuss my second point on why the procedure provided in liberalizing Articles 12, 14, and 16 of the Constitution may be, again I stress the word, may be constitutionally suspect. But let me just submit this short point in the interest of time, that the use of the phrase unless otherwise provided by law is vulnerable to another constitutional challenge. Number one, Your Honors, allowing Congress to use its law-making powers to amend the Constitution may be questionable. Number two, the laws that will be passed by Congress for this purpose will not be approved by the people in a proper referendum. Under all our constitutions, 1935 Constitution, 1973 Constitution, and especially under the 1987 Constitution, any and all changes in the Constitution, whether they come from a constitutional convention, whether they come from a constituent assembly, or whether they come from a people's initiative, have to be approved by the people in what is known as an obligatory referendum. That approval by the people cannot be set aside, cannot be short-circuited. So, again, these are some of the constitutional problems. But again, what is the way out? My respectful submission, Your Honors, is just to do away with this praise unless otherwise provided by law. Just repeal these three restrictive provisions of the Constitution, which you want to be out. And in addition, you just repeal Article 2, Section 19 of the 1987 Constitution, which states, the state shall develop a self-reliant and independent national economy effectively controlled by Filipinos. Include that in the repeal. If all those provisions will be repealed, then Congress, in the exercise of its law-making power, can enact all the necessary laws in order to attract these foreign investments. By the repeal of all those provisions, you let go the power, the lawmaking power of Congress. That is, to me, how simple it is. Thank you, Your Honors. I have no time to really expand more on these submissions. And if I may be allowed, I will submit to this House a more expanded version of my position. Thank you, Your Honors.
Thank you very much, the Honorable former Chief Justice Reynato S. Puno.